All right, we've gone over a lot of the rights that are specifically mentioned within the Bill of Rights, but what about unstated rights? What if are you entitled to rights that aren't specifically written in the Constitution? And that's been a topic of confusion and controversy throughout American history. So one of the terms that you should be familiar with is penumbra, which generally has like a scientific sort of application. It's sort of like the shadowy region produced by an eclipse. It was referenced legally by Justice William O. Douglas in a 1965 Supreme Court case, arguing that there are some rights that are not specifically mentioned in the Constitution, but are related to rights that are. So think about it almost like implied powers, but from like a right standpoint. You know, we talked a lot about the necessary and proper clause, and like the government can do what they want to do, even if it's not listed in the Constitution, by linking it up to something that is. And it's kind of the same thing that like this is looking at it from like a right standpoint. That you have specific rights that are listed, and then could you kind of like link up other rights that aren't mentioned to those that are? And this has been something the court has dealt with for a while. So, an example like privacy. So, the word privacy is not listed in the Constitution specifically, but like lots of amendments relate to sort of like the concept of like privacy, like freedom of speech, freedom of religion, not having to quarter soldiers, the Third Amendment, like search and seizure rights. Like it's clear that though privacy was not mentioned specifically in the Constitution, this is something the founding fathers thought was a right that Americans had. They believed in very strongly. So essentially, the Supreme Court has argued that privacy is a right that in many cases Americans have, despite the fact that it's not specifically listed in the Constitution. So, for example, what kind of like modern day Supreme Court issues have been like ruled on the basis of privacy? Well, like abortion, like Roe v. Wade, famous, infamous Supreme Court case in which it was ruled that essentially that what a woman wanted to do with her body was a matter of privacy, and that this paved the way to allowing women to pursue abortions if they wanted to. Now, that very much has been a controversial Supreme Court verdict because, again, people that oppose abortion will argue that there's no specific guidance in the Constitution that allows the government to say that abortion should be legal. But the argument made in Roe v. Wade was that privacy was an unstated right that is clear if you read through the Constitution, and that this was a related issue. Or the right to contraception. Supreme Court case in the 1960s that essentially said that states couldn't declare contraception to be illegal. Again, this was like a matter of privacy, despite the fact that it doesn't specifically relate to a singular amendment in the Constitution. Or right to die laws. Oregon in 2006 passing the Death with Dignity Act that allowed individuals that were given like a terminal illness diagnosis to essentially um, pursue the help from a physician of like ending their life to avoid pain and suffering. Again, this was considered to be a matter of privacy and was actually upheld by the Supreme Court, right? Or like spouse partner relationships. Loving versus like Virginia in 1967 outlawed like a state law in Virginia in 1967, not that long ago, that prevented interracial marriage. This was considered to be a matter of privacy. Or Obergefell v. Hodges, which dealt with same-sex marriage in 2015, struck down state laws that invalidated same-sex marriage. So again, privacy is something that has been protected by the Supreme Court, despite the fact that it's not listed in the Constitution specifically, because it relates to so many of the things that are.